I have an idea for a very profitable and amazing invention. This would, and I think, permanently replace all light truck bed covers and possibly an application for sedans and SUVs. But I have no clue as to where to start. I'll say that I made rough sketches of my idea, but all in all, I'm very green when it comes to building a prototype and drawing sketches. I want to submit a patent, but I have no idea what to do, how to get there. Any help would be much appreciated. Okay, well, I love it. Truck bed cover. I've been a truck owner, no longer a truck owner, but truck bed covers. I think they're kind of talking about a canopy or just any type of a cover on it. Can be quite important, especially if you run out of room in the cabin. You want to be able to store something and not have it get all wet. What I will say here is, to get started, one concept is, and this maybe it's sort of just a clarification. They mentioned prototyping. You don't have to actually ever prototype or build in real life your invention to get a patent on it. You've just got to be able to lay it out with words and drawings and convince the examiner with that it's novel, non-obvious, and has utility. So sometimes there is, and it makes a lot of sense in a lot of cases to go build it out, make sure that it is and works the way you think it does. But if you're truly, concerned about the cost, or maybe the other side where you're certain it's going to work, and you want to just move forward and file the thing without having to, build it first, you don't have to, right? There's no more need to submit the actual invention. I think the only times they'll do that is if you're claiming a perpetual motion machine. They'll say, "Bring it in,
bring it on in."
Yep, love to see it.
A model of what you were going to patent used to be required way back.
Right.
Yeah. So that used to be a thing, but it's not a thing anymore. My other thoughts, because he was asking about prototyping. Sometimes prototyping is about finding out whether or not your idea is actually something you want to move forward with. And not all patent applications are intended to move forward with, right? How many times has a company got a patent almost specifically so that they could sit on it? They own it. They don't want it in the market. It's the disposable razor problem that you may remember, right? It's like, I don't remember what company it was, but they made proper old school razors, and then disposable razors started to come out and cut into those sales, right? So the idea was, well, we'll get a patent for a proper disposable razor, and we simply won't make it.
Got it.
Because it cuts into the sales of our existing product. So yeah, sometimes you need to know, you need to do the due diligence to find out that, because you want to build it, right? So you want to know that it works. So you're going to do some prototyping and da da da. As soon as I hear prototyping and da da, all of that stuff, my first thought is shut up, stop talking, don't talk to anybody, period. I mean, it's the first piece of advice I give anybody is check out the statutes of limitations and don't talk to anybody. Those two things, right? And that's where you need to have the right kind of NDAs and things like that. These are the sensitive bits, and those things have to be in place before you start talking to somebody who does have the skill set to produce the trial products, so that you can evaluate them, do that prototyping.
Yeah,
that's not really an answer to the question, though. It's like, where do you start, right? But
I think it is. I think it is. Yeah.
Simply don't start until you know that you're not offering up your idea and starting that 1 year clock, right?
Huge points. Yeah, I think this was a simple question, but I think it's got really cool. We have a lot of different angles we could answer this. Trying to be simple is prototyping it, building it is very useful. If you as an inventor need to prove it to yourself that the thing works,
right.
Or that's huge. So if you can do it on your own, that's best. If you need to go to a third party to bring it about, make sure you have a very nice attorney-approved contract with a non-disclosure agreement to make sure that whoever or what company you're hiring to build it will keep it confidential. Because like you said, you do not want to start that 1 year clock, which is, hey, as soon as it's in the public or as soon as it's being sold, now you have 1 year to file it. And then the next thing is, while you're going through that process, make sure that it's, there's a sizable market. Okay. The biggest point about getting a patent is you want to make money. And so if if you're going to be, going after something and it's such a small little niche, area of the market, you don't see you're going to be able to recoup your investments. You don't need a patent, right? You can go kind of have this hobby, or kind of a smaller vision in terms of what your sales look like. What are your goals? Kind of that, right? But the other side is that once you do convince yourself that you want to proceed with the patent, like David, you mentioned on the trademark side, do some diligence first. You want to make sure you do a thorough patent search to go see if, even though you think it's great and it's awesome and you can build it, has anyone else done it before? Or is it so close to something else that's been done before that it's not going to be worth going through filing?
Yeah. And a lot of your opportunities, China is actually getting easier to work with, not harder, but the regular NDAs that we might use here might not work there. Like the same document in China is called an NNN. So non-disclosure, non-compete, non-circumvent. So there's this concept. I didn't do it, but my uncle did because I circumvented it, right? So they just have to have additional language. And then you have to respect that those are it's just a different jurisdiction, right? I was saying that trademark rights come from use. That's not true in China. So if a trademark is involved and you're starting to engage with China, then one of the first things you might do is go and file for your trademark in China. It's another reason to make sure that you work with somebody who at least knows what to be worried about.
Yeah, issue spotting. Yeah, exactly.